Hello, realtors. I always have great tips for you, and it can actually save you a lot of money or earn you some money. So today's tips is in regards to earnest deposit money. My name is George Almodovar. I'm with Bellalago Experts, powered by LPT, and today I want to go over earnest deposit and how you benefit. On the exclusive right of sale listing agreement, there's a line which is 127 that I want you to understand and pay attention to me very carefully, because most of you don't know that, and I know this because there are even title companies that don't know this. I thank God for Lou Oliver, real estate attorney Lou Oliver, who owns Oliver Title Law, because he always has my back, and he's a licensed real estate attorney, and he educates me a lot, which is why you should also use him, right? I have many friends that are with different title companies, but he becomes very beneficial when you have a great team that you can always count on and ask him for legal advice. And I will also add that he even helps me, sometimes even answers back to the other agent, okay? If I'm representing you as the selling agent, the listing agent, you rest assured that I will represent your best interest and I will fight on your behalf. Many agents will not fight, or many agents don't even know what the hell they're doing. Excuse my language. That's the truth. But I want to teach you so that way you can always make a little extra fun. So let's go right here to the board. And if you look at the exclusive right of sale listing agreement, I even highlighted for you so that way you can see it, which is line 127 subsection E regarding retained deposits. And it says the following: as consideration for broker services, broker is entitled to receive, and I put here 50%. Notice that if I would have put nothing, it automatically says 50% if left blank. Of what? Of all deposits that the sellers retain as liquidated damages for buyer's default in a transaction, not to exceed paragraph 8A fee, which is basically the commission you charge them. It cannot obviously exceed the commission, but whatever the earnest deposit is, you're entitled to up to 50%. You can put more, it's up to you. Whatever you agree with your client, you want to make sure you go over this exclusive right of sale listing agreement with your client so they are aware of what you are expecting. Now, nevertheless, I assure you that in order to get that earnest deposit, there's a lot of fighting that has to be done, a lot of negotiating back and forth. Not every agent wants to be paying that, but you are entitled to that, okay? Now, make sure it's signed, because you're going to need this with the title company, and I'm going to take you right now to these forms so you can see it for yourself, okay? So, here we go. Let's go right here. Now, I want you to see that the buyer's agent, this is the property that I representing the list as a listing agent, and they deposit the earnest money. As you know, they ask, usually people ask 7 days, they have up to 15 days, but they ask for 10 days home inspection contingency period. Well, they had 10 days to do the inspection. Yes, the seller was having a little issues. It was hard for them to get in there, but I personally got them in there. And what happened was that after I got them in there, they did the inspection. They remained silent. And then after, or within the 10 days, they told me they would like the roof to be fixed, and the AC allegedly wasn't working. Now, we told them the AC was working. The inspector could come back and reassess the AC. It was just a clog line. And obviously when you unclog the line, basically the AC starts working again. But the roof had just beginning to have a little slight leak. It was so minimum that it had not even gone through the sitting sheetrock. But nevertheless, I saw it myself. I saw it was kind of damp, so I said, okay, yes, there is a slight leak. Now, being that my client had lowered the property $10,000 of the listing price, they was not willing to pay for that. And we were going back and forth. I even negotiated, tried to offer them $1,000 to take care of it. I even got the contract. The contractor came in and told me, okay, that job is going to cost about $4,200 because they wanted to replace the vent. Well, that's what the slight leak may have been from. I believe, contractors sometimes easier to get it sealed, but they want to make money as well for their job. But nevertheless, you can see what I wrote, because after all that, and after we offered, because they wanted to walk away after 10 days. We had 10 days, they waited a whole 30 days on the contract to then try to walk away from the contract. And they act as if we were negotiating, because they did an addendum that basically stated, they would like this to get fixed. And you're going to see a Lou Oliver answer correctly, because I said the same thing. But I said, just so you see, good evening, for the record, seller will not release buyers from their contractual obligation. Therefore, buyers will forfeit the earnest money deposit for breach of contract. They have even conveyed to me that the AC is working great and can be re-inspected and the minor roof leak will be taken care of by the seller by a licensed and insured contractor at no expense to the buyer. My seller actually decided to do this after the fact because we knew there were BS. They just happened after 30 days. They were from Brazil. They came to see the property. Maybe they didn't like it, whatever the case may be. But this is 30 days later on a cash offer. So you imagine there was already a lot of red flags that gave me the instant in which I told my prospects, my sellers, that there were red flags. Sure enough, I was correct, including the earnest money deposit. When you have the earnest money deposit, guys, please don't ask for $1,000 like some of you do. Try to get a lot more, because if the client is really interested in buying the house, they should be able to, right, put the money where the mouth is, right? They should be able to put the earnest deposit, because that shows him his good faith intention. It shows that he's serious, and you got to protect your client, because you got to work out for your client's best interest, not yours. But nevertheless, keep in mind that you as a listing agent or broker, in my case, there's ways that you could make some money. So, it says right here, we have informed the buyer's agent of this fact, and they still want to proceed with canceling the contract. Therefore, as expected, they changed their mind after seeing the house yesterday and after many weeks on the contract. Moreover, we lost prospect buyers that were interested in buying, but we went ahead with a cash offer instead. My client feels that when they wanted to cancel the contract in writing, the buyers were not interested in doing so. Now, after dealing with personal issues and stress to accommodate the buyer's request, that includes finding where they was going to live, they have made other living arrangements at this time and will want to sue, not just arbitrate for breach of contract and mental distress. I'll see if I can defuse the problem, but please note, should there be any legal actions after arbitration, the losing party will have to pay legal fees on both sides or as requested by court. Hopefully both parties can solve this matter amicably. Kind regards, I did this because some agents know that they could actually arbitrate, because you signed the contract. Yes, they can arbitrate, but that doesn't mean the seller is going to want to continue arbitration. They'll go, but if they believe they're being dishonored, like this guy here, basically it was 30 days, right? Not fair. A cash offer. We were ready to close, and we didn't close because they came at the last minute, changing their mind and try to use the issue that they agreed upon after they gave us the addendum. We answered them and told them no, we were not going to make any repairs, that we lower the price. If they want to continue, they have to take care of it themselves. And they did. They continue. Okay, they never came back to me. It doesn't say, and you're going to see the legal verbiage that Lou Oliver said, because it's great, because I want you to understand. So, by the way, realtors, don't forget Lou Oliver. He will definitely help you out. And again, this is what we signed, right? The 50%. Okay, so that takes care of you. Okay, that protects you and your interests, not just the sellers. But here's Lou's situation. Okay, and he said, the situation is both common and also crystal clear. If the buyer decides to cancel the contract during the inspection period, then the buyer must state as much clearly and in writing. Simply requesting, demanding, asking for the seller's concession or back and forth discussion does not automatically extend the inspection period. The seller is under no duty to respond positively or indeed respond at all to the buyer's request. If the buyer is not satisfied with the seller's response or lack thereof, then buyer is absolutely entitled to cancel, but must say so in writing before the expiration of the inspection period. And it says, this is real estate contract law 101. It is elementary. There is no assumptions that the mere one-sided buyer demand for a seller's concession either extends the inspection period until sellers respond or constitute as an implied cancellation. If the buyer intends to cancel, if seller did not agree, then the addendum should have been accompanied by an email that said more or less, and he puts, attached is a buyer's signed addendum requiring seller's concession. If seller does not execute and return this to the buyer by no later than the end of the inspection period, then this email shall constitute buyer's cancellation of the contract and demand for return of escrow deposit. Alternatively, buyer could also just submit the addendum and then wait for a reply, and if satisfactory reply did not come before the end of the inspection period, then buyer could send a cancellation email just before midnight on the last day of the inspection period. Also, alternatively, if negotiations are still ongoing, buyer can also submit an addendum extending the inspection period for further negotiation or state in writing that they are canceling if not extended. In short, a buyer's cancellation cannot be legally assumed or inferred. It must be stated clearly and in writing. Seller is not required to read buyer's mind and read meaning into it. Okay? He further put, also on the flip side, seller does not have a right to assume a cancellation intent. For example, the seller now has a better offer. Seller is not entitled to interpret the concession addendum as a cancellation. So seller can now go take better offers. This is a double-edged sword. In fact, many buyers will make demands of seller within the inspection period as a kind of a trial balloon, no harm in asking, but nonetheless will still want to proceed with the contract even if the seller says no. This part is part of negotiating. A very high percentage, 25 to 50% of the buyer's client, decide to ask for a concession in the hopes of getting one, but will still continue to buy the house even if they didn't or don't get it, especially the present market on very limited home supply. This is a common realtor error, assuming incorrectly that the buyer concession demand extend the inspection period clock or implies a cancellation if concession is not granted. It is a major topic of this new realtor seminar, which by the way Lou Oliver does. If buyers consult with legal counsel or an experienced broker, they will tell them the same thing. So you see guys, it says bottom line, it is too late for the buyer to cancel or receive refund of deposit. That should have been done expressly in writing prior to the end of the inspection period. If buyer walks now, seller is entitled to deposit. Seller will win this on a summary judgment if it goes to litigation. Lou Oliver. And you see, guys, this is one of the reasons to have somebody powerful in your team. So that way, if things hits the fan, you have somebody as a real estate attorney. Imagine he holds gold. When he answers, not just you, he's also answering the other party. Okay? So it looks good on your behalf as a real estate agent, and he holds more weight. So the prospect buyer could either realize that they screwed up and release the earnest deposit. Obviously, you are entitled based on what you stipulated on the listing agreement to 50% or whatever you stipulated. I usually go for 50% with me and my client. Make sure you tell your client and make sure you speak to them prior to so they understand what's going on, because it does take work. It takes me to reach out to my team, paperwork, back and forth, arguing, dispute. There was a lot of things that was said on the other side, which I'm not going to mention here, but you got to know how to do it so you could get your client deposit, which helps, and it also helps you as well. I hope you like this. Please like, comment, and share. And don't forget, thank you, Lou Oliver, for always having my side. Thank you. Appreciate it.